In the hallowed halls of the Federal Court in Putrajaya, a verdict was forged that would challenge the very foundation of patient trust and medical duty in Malaysia. This is not just a case, it is a battle for accountability following tragedy. We are diving into Zulhasnimar binti Hassan Basri and Dr. Kuppu Velumani 5 MLJ 438, presided over by a formidable panel, including Rao Sharif PCA. This court faced a searing question: where does a doctor's duty end? On one side, the bereaved appellants Zulhasnima, Kairina Putri, and Saliman bin Saad seeking justice. On the other, the powerful respondents, Dr. Kuppu Velumani, Dr. Marle Abu, and the Ampang Putri Specialist Hospital. This is the story of a legal fight that redefined negligence in the operating room. Brace yourself as we uncover the true chronology of events.
Zulhasnimar binti Hassan Basri, the mother and also the first appellant, was 36 weeks pregnant with her infant daughter, Kairina Putri binti Sariman, which is the second appellant. She had a history of previous cesarean section, so the mother had specifically chosen the first respondent, Dr. Kuppu Velumani, as her obstetrician and also as her gynecologist. The mother presented to the Ampang Putri Special Hospital, which is the third respondent, complaining about the abdominal pain. After initial check by nursing staff, she was admitted to the ward and given medication to stabilize her blood pressure. Later that morning, Zulhasnima was found collapsed due to the severe bleeding. A cord blood was declared. She was quickly resuscitated and rushed for the emergency CS by Dr. Kuppu Velumani within the first 15 minutes. The cesarean section was successful and the infant was delivered with life within the first 30 minutes of the collapse. However, because of the event, the collapse had caused a significant loss of oxygen for the infant, resulting in her suffering from severe cerebral injury. After the subsequent hysterectomy performed by Dr. Kuppu Velumani, with the help of the second responder, Dr. Mari Abu, it was discovered that Zulhasnima had a ruptured blood vessel on the outer surface of her uterus, which is the cause of the sudden bleeding and collapse. Zulhasnima then sued the doctor, the assisting doctor, and the hospital for the negligence. At the High Court, she claimed that there was a delay in the CS, which she said that she was in the labour shortly after admission, and an earlier CS would have prevented the infant disability. She also claimed that there is a negligent diagnosis on the part of the doctor and the nursing. The doctor and the nursing staff failed to diagnose that Zulhasnima was in labour and instead gave her the penalizing drugs, delaying the emergency procedure. She also claimed that given the Zulhasnima history of the previous CS due to the cephalopelvic disproportion, the doctor should have foreseen the risk of uterine rupture if the delivery was delayed. Another point that she claimed is that there is inadequate resuscitation by the doctor. The first respondent failed to adequately resuscitate Zulhasnima when the cord blue was sounded, and the second responder failed to assist. Lastly, the hospital system failure was also brought to the light. The hospital had direct negligence from its nurse and the fundamental system failure, making it vicariously liable for all the failure. As a son, I understand the sorrow of the Zulhasnima, but the court has laid a strong resolve. High Court has dismissed all claims that have been brought. The court found that the appellant failed to prove that Zulhasnima was in labour at the time of the uterine rupture. Instead, the court accepted expert evidence that the collapse was resulted from the ruptured blood vessel due to the placenta previa, a rare condition detectable only by the surgery. The judge concluded that the doctor could not have been expected to detect or foresee this rare event, clearing the first and second respondent from any form of liability. Furthermore, the 15-minute response time was found to be acceptable even under the international standard, so the hospital was also clear for the vicarious liability. As a mother, Zulhasnima can accept the judgment by the High Court. Thus, she appealed to the Court of Appeal. Court of Appeal then held that the appeal was dismissed, affirming the High Court findings. They agreed that the trial judge correctly handled the issue of the hospital liability and that there was no delay in the delivery of the infant, concluded that the mother was not in labour until the collapse. Hearing the judgment, Zulhasnima didn't bow down. On the other hand, she appealed again, but this time she appealed to the highest court in Malaysia, which is the Federal Court of Malaysia.
There are two legal issues in this case. The first one is whether the Bolam test or the test in the Australian case of Rogers and Whittaker in regard to the standard of care in medical negligence should apply, following conflicting decisions of the Court of Appeal in Malaysia and legislative changes in Australia, including the reintroduction thereof a modified Bolam test. The second one is whether in negligence a hospital authority may, by reason of a non-delegable duty of care, be directly liable for organizational and system failures, as decided by the Supreme Court of England in Woodland and Essex County Council. Counsel argument. The plaintiff. Number one, the plaintiff was already in labor and doctors negligently failed to diagnose it. Number two, there was delay in management and resuscitation, causing the collapse and infant's injury. And lastly, hospital system and nursing failures contributed to the harm, which make hospital is directly and vicariously liable. For the defendants, number one, the plaintiff was not in labor, so no early C-section was needed. Number two, collapse was caused by rare, undetectable conditions called placenta percrita, not negligence. And lastly, there was no delay in the respondents because the response time met international emergency standards. Now let's move on to the ratio decidendi, and let's start with the first issue. To tackle this issue, we must first familiarize ourselves with the development and history of the Bolam test. So first, the Bolam test. The test was pertaining to the duty and standard of care of a medical practitioner towards a patient. The judge of this case held that where you get a situation which involves the use of some special skill or competence, then the test whether there has been negligence or not is not the test of the man on top of Clapham Omnibus. Because he has got this special skill, the test is the standard of the ordinary skilled man exercising and professing to have that special skill. The judge then pronounced that a doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. And vice versa, a doctor is not negligent if he is acting in accordance with such a practice merely because there is a body of opinion that takes a contrary view. The Bolam test then became the primary case to determine a doctor's standard of care towards a patient. Then we have the Sidaway and Bethlehem Royal Hospital case. This case was mainly concerned with the medical professional duty to advise of risk towards the patients. In this case specifically, the Bolam test was applied and the judges made the decision by solely relying on the Bolam test. However, in this case, one of the lords had a strong dissenting view, and his name was Lord Scarman, who called for a different test to be applied in respect of a doctor's duty to advise of risk. While accepting that the Bolam test may continue to apply to diagnosis and treatment, Lord Scarman was of the view that there was a duty on the part of doctors to advise or warn of the risk to the patient. Lord Scarman's point was that the patient's right to make his own decision may be seen as a basic human right and should be protected by the common law. In his lordship's view, Lord Scarman's view, the failure to warn a patient of the risk inherent in the operation which is recommended constitutes a failure to respect the patient's right to make his own decision. Thus, his lordship saw no reason why, if the risk unadvised materializes and injury or damage was caused, the law should not recognize it and enforce it as a right of the patient to be compensated by way of damages. And after that, we have the Australian High Court case in Rogers and Whittaker, which decided differently than the previous cases. In conclusion, for simplicity to explain, the Australian High Court held that the law should recognize that a doctor has a duty to warn a patient of a material risk inherent in the proposed treatment. Thus, the principle established here is it is now the court rather than a body of respected medical practitioners which will decide whether a patient has been properly advised of the risks associated with a proposed treatment by applying the materiality test. The court would no longer look to what respectable members of the medical profession would do as being the yardstick to govern the standard of care expected in respect of the duty to advise. Now, the next significant case in development of Bolam test is Bolito, which is the administratrix of the estate of Bolito Disease and City and Hackney Health Authority case. In Bolito, the development made to the Bolam test was that if the body of medical opinion does not withstand logical analysis, the court may hold that it is not reasonable or responsible and may then depart from it.
In effect, Bolito retained Bolam test for all purposes in respect of medical negligence, but made it subject to the condition that for the expert opinion to be acceptable to the courts, it must be capable of withstanding logical analysis. Then we have the history of Bolam test in Malaysia itself. The first case of the Bolam test being applied in Malaysia was in the case of Ong J in Chin Kiao and Government of the Federation of Malaya and another. And since then, the Bolam test was applicable in all Malaysian courts. But then came the case of Fu Fiona and Dr. Su Fok Moon and another. This case refused to follow the Bolam test and instead followed the test in the Roger and Whittaker test, which is only limited to a doctor's duty to advise. And since then, two inconsistent lines of court's decisions on the principles to be applied in medical negligence cases has arisen.
Now we can finally discuss on the answer of the first question. It was found that the trial judge was fully aware of the applicable test, which is to be applied for cases of negligence against doctors. She was fully aware of the Bolam test, the dissenting view of Lord Scarman in Sidaway, which was later developed in Rogers and Whittaker, which was followed by this court in Fofiona. By using and guided by the said authorities, the trial judge came to the conclusion that the appellants had failed to prove on the balance of probabilities to establish that the first and second respondents were in breach of their duty of care by using the Bolam test, when the appellants failed to show on evidence that the first appellant was in labor to merit an earlier CS to be performed on her. The trial judge also found that the appellants had failed to prove that there was uterine rupture, which was foreseeable and preventable by the first respondent in view of the first appellant's history with regard to her first pregnancy. On the other hand, sufficient evidence was established to show that the first appellant was suffering from the abnormal presentation of the uterus, which is the rarest kind, known as placenta percrita. According to the trial judge, such abnormal presentation was rare and cannot be detached by any sophisticated machine except by way of surgery. With regard to the standard of care for diagnosis or treatment, the Bolam test still applies, subject to the qualifications as decided by the House of Law in Bolito. And the court also found that there was no need to apply the test in the Australian case of Rogers and Whittaker, as this case did not concern on the duty to advise of risk. This question also include the objection of the defendants about the finding of the facts made by the trial judge, which was readdressed again in this court. But in the end, after the court reassessed the trial judge's deductions, it was found that the respondents were once again not negligent and all the findings of facts remained the same. And for question 2, was not answered by this court.
Next, for the judgment, the court made a distinction between the application of Bolam test and the principle of Rogers and Whittakers. The court decided that Bolam test shall be applied on cases concerning diagnosis and treatment, where another medical practitioner's opinion shall decide if there is a negligence or not. Whereas in Rogers and Whittakers, the legal ruling shall apply when it concerns the duty to inform the patient of material risk. It will be taken into consideration if the patient would attach significant to the risk. The court made a prominent distinction here on where, why, and on what basis should we apply Bolam and Rogers' principle. For the judgment of second legal issue, in this case, the doctors or the expert who testified didn't all agree. So there is a different opinions among the medical expert. But even after considering all evidence and applying the Bolam test, the appellant still could not prove that either the first or second respondent was negligent in diagnosis and treating them. Hence, if the first and second respondents are not negligent, the vicarious liability of the hospital, which is the third appellant, should not come into picture at all. So, after full reviewing and analyzing the case, do we agree or not with the decision of the court? So, we agree with the judgment made by the judges because the doctor indeed owed his duty of care towards the patient. However, there is no breach of duty by both doctors because both respondents did their job as a medical practitioner by monitoring the appellant, and there was also resuscitation took place in the ward. The appellant also failed to prove that she was in labor and that the doctors delayed caused the damage toward the second appellant. Moreover, the opinion of other medical experts further support that there is no breach of duty of care by both respondents. Hence, if both doctor is not liable for negligence, the hospital will also not be vicariously liable towards the claimant. So we agree with the decision of the court that the appeal should be dismissed.
On record of this case, we took another case which is Dr. Hari Krishnan and another against Megat Nur Ishaq bin Megat Ibrahim and another appeal. So this case happened where the plaintiff, which is the patient, went to Dr. Hari because he had a serious eye problem, which is a giant retinal tear in his right eye. So Dr. Hari told him that he needed immediate surgery. So the first operation was done at the hospital. After the operation, the patient claimed that his eyes were still hurting and felt a lot of pressure. When Dr. Hari checked him, he said that the retina had folded outward and the patient needed a second surgery urgently. The patient asked for a scan to confirm this, but Dr. Hari said a scan wasn't necessary. For the second surgery, the patient wanted the same anesthesis from the first operation, which is Dr. Malvalan. But Dr. Hari told him that the anesthetist on duty and Dr. Namazi is just as good as him. So the second surgery went ahead with Dr. Namazi instead. During the second surgery, something went wrong. The patient actually woke up in the middle of the surgery. He regained consciousness and moved back while the doctor was using a laser on his retina. Because of that sudden movement, he suffered supracortical hemorrhage, SCH, which is a serious bleeding inside the eye. After this, he had a terrible pain and constant bleeding and also eventually lost a total vision in his right eye. So his eye officially became a permanently blind. So now, let's look at the case involving Dr. Hari and Dr. Namazi. In this case, the patient sued Dr. Hari and Dr. Namazi and also the hospital, claiming that their negligence caused his serious injury, which is including the blindness in one eye. So the allegation was straightforward. Both doctors failed to warn the patient about crucial risks, especially the risk of waking up in the middle of the operation and the possibility of going blind. On top of that, they failed to properly manage the patient during the surgery. And because both doctors were practicing under the hospital itself was said to be vicariously liable, which means that the hospital is responsible for the action of its doctor. So, what did the Court of Appeal decide? The Court of Appeal confirmed the High Court's decision and agreed that all three defendants were at fault. First, the court held that Dr. Hari should not have advised the patient to go through the second surgery. The second procedure carried unnecessary risks, including the risk of the patient waking up or barking, which eventually caused the blindness. Second of all, Dr. Namazi, which is the anesthetist, was found negligent because he failed to keep the patient fully sedated and pain-free during the operation. If the patient had been properly anesthetized, the barking incident likely would not have happened at all. And finally, the court held that the hospital was also responsible under the doctrine of non-delegable duty. This means that even if a doctor is not a full-time employee, the hospital must still take responsibility for the safety of its patients. It cannot simply shift the blame to independent contractors. In Zulhasnimar, the federal court was in favor of the doctor. Why? Because the doctor successfully fulfilled the Bolam test, meaning that he managed to prove that his actions were supported by a responsible body of medical professionals. So, in Zulhasnimar, the doctor's conduct was considered acceptable based on the medical practice standards. But in Dr. Hari's case, the situation was very different. The doctors failed to meet the standard of care, failed to warn the patient of material risks, and failed to conduct the surgery safely. Even worse, their action directly contributed to the patient's injury. This case creates a hybrid model, which is a half doctor-centric and half patient-centric. So what's the impact? It means that Malaysia is no longer following one clear and unified standard, which is every medical negligence case now requires the court to split the doctor's conduct into categories. First, if it involves how the doctor treated, diagnosed, or managed the patient, then Bolam test will be applied. However, if it involves what the doctor told the patient about the risk, then the Roger Whittaker principles will apply. So, this hybrid approach shapes how future cases will be argued. Lawyer will now have to carefully decide, is this issue about treatment or is it about advice? And because a different test apply, the outcome of a case can change completely based on how the issue is framed.